comes to academicians, I believe that their level of arrogance cannot truly be fathomed until it is realized that they had the audacity to set up their own court system. A truly spectacular level of criminality. Among the mountain of evidence that I and likely many others retain as it relates to these institutions, this is perhaps the cream of the crop as far as evidence of criminality and malfeasance willfully executed goes. This particular institution, shall we say, self-appointed and created as though, well, self-appointed created, nobody voted for these people, and they obviously retain no lawful authority, but that doesn't stop them because they'll just go ahead and claim it anyway. And this evidence is taken from the 2nd of April 2020 Faculty Senate packet. Now, mind you, this University of Nebraska-Kearney Faculty Senate is not actually a Senate. No one voted for them. They basically appointed themselves into existence. And so these people, who are not senators, they hold no legislative power. They're not able to do anything as far as it regards law or anything else. Well, they run around calling themselves senators. And, of course, they believe themselves to be justices as well. So these illustrious Senate justices, in this document, outline their court system that they decided to set up based off of a, I don't even know what you call it. I suppose it's ad hoc committee court. It's something special. It states that under a definitions section, or at least above it, states that composition: one tenured faculty member holding the rank of associate professor. So they have ranks now, I suppose. Or full professor from the elected by each undergraduate college, and 3 tenured faculty members from the Senate holding the... That's, of course, not the Senate, not the Senate of Nebraska, and not the Senate of the United States. That's the faculty Senate of this university. Holding the rank of associate professor or professor selected by the faculty Senate. Total 7, that's cut out, 6 members. Wow. So, under definitions, it states, as most legal documents have definitions where they define what they mean by certain things. It states, A, bylaws shall refer to the bylaws of the Board of Regents of the University of Nebraska. Faculty members shall mean any staff member of the University of Nebraska-Kearney holding the academic rank. So it's an academic rank now. You know, like military personnel, they hold ranks. So I suppose, is an academic rank, according to them, superior to a general? Maybe? Probably. Their level of arrogance appears to be on par with that type of thinking. Assistant professor or above. Professional staff serving in dual capacities as administrators shall be included under this procedure only insofar as it relates to their academic position as distinguished from their administrative status. Academic freedom shall refer to the principles contained in the bylaws, section 4.2. Committee shall mean the Committee on Academic Freedom and Tenure of the Faculty Senate of the University of Nebraska at Kearney, or the hearing committee thereof established to act in a particular case. The term grievance committee shall mean the grievance committee of the Faculty Senate of the University of Nebraska at Kearney. President shall include the authorized representative of the president of the NU system, but such authorization to act shall not be extended to the chancellor or a staff member of the University of Nebraska at Kearney, or to the Chancellor or a staff member of any other campus of the University of Nebraska. Chancellor shall mean the Chancellor of the University of Nebraska-Kearney and shall include the authorized representative of the Chancellor, but such authorization to act shall not be extended to a dean with collegiate or divisional responsibility or to a staff member of any such college or division. You see, the Army has divisions. So not only do they have ranks, divisions, and a Senate, but they also have their committee court system. G. Tenure and tenured faculty members shall refer only to persons holding continuous appointment acquired in accordance with the bylaws. Association shall mean the legally recognized bargaining agent of the facility, the University of Nebraska-Kearney Education Association. Now, under Section 3.7, interference with committee investigation. If there is a reasonable basis in fact for the committee to believe that any individual is in bad faith impeding the committee's investigation of a complaint, pursuant to Section 4.13.2 of the bylaws of the Board of Regents. So now they're listing the bylaws of the Board of Regents as though that's the only law that exists. They don't need to abide by the Constitution, the supreme law of the land. They don't have to even abide by any other such court system that would exist in the United States. The only thing that they have to look to are sections of the bylaws of the Board of Regents. That's their supreme law, at least as far as this this court committee goes. The committee may refer to such matters to the President, Chancellor, or to the Professional Conduct Committee for remedial action. One wonders if those remedial actions might have some sort of natural causes component to them. That seems to be going around, and very popular among such corrupt individuals as these. In Section 3.8, Standards for Consideration of a Complaint, it states, in its deliberation concerning any complaint, the committee shall be guided by applicable state and federal law. Oh, now they recognize the laws of the state and federal. The bylaws of the Board of Regents, the bylaws of the University of Nebraska-Kearney, the University of Nebraska Governance Manual, the bylaws, rules, or regulations, the relevant administrative units, college, department, division, etc., and general academic customs and standards. Refusal by any person to make documents available, testify, or take personal responsibility for testimony will prevent the committee from receiving evidence which may be relevant to its investigation of a complaint. The committee in its deliberations shall take any such refusals into consideration in making its findings of fact, decisions, and recommendations in the final committee statement on the complaint. Here they're using legal jargon, but they have absolutely no ability to make findings of fact or decisions. It's something special, these people. Wow. Informal procedures. Section 4.1, referral of complaint to the department and college if informal resolution attempts have not been made. When a complaint is accepted by the committee, it is expected that there had been mutual efforts at the department and college levels to satisfactorily resolve the problem. If the complaint does not include sufficient evidence of these efforts, the committee may suspend its investigation and refer the complaint to the complainant's department chair and college dean, respectively and sequentially, for up to 10 working days at each level. If there is no mutual resolution at either of these levels, the committee will resume its investigation. Section 4.2. Initiation of proceedings that involve faculty dismissal. So here they're initiating proceedings. So very serious and grave indeed. If the informal efforts, Section 4.1, have failed to resolve satisfactorily a dismissal question, a complaint falling in a category described by Section 5 or 6, the matter shall proceed to a higher administrative level. The Chancellor may seek a personal conference or conferences with the persons involved. Prior to any such personal conference and within 15 calendar days of notification of the dismissal matter, the Chancellor shall transmit in writing to the faculty member. So here this Faculty Senate Committee group is stipulating responsibilities to the Chancellor of the University, an employee of the Board of Regents, not this Faculty Senate. This is for sure operating under the color of law and definitely outside of the scope of responsibility. But let's continue. In section 3.3, it makes a time limit for filing a complaint. And in section 3.4, it states initiation of proceedings. Proceedings involving the dismissal of a tenured faculty member are initiated by the President as described in section 5.2. Other proceedings governed under section 6, 7, or 8 may be initiated by any faculty member filing a written complaint with the committee chair or the President of the UNK Faculty Senate. This is something else. In section 3.5, determination of jurisdiction. Yeah, because a committee for the Faculty Senate, which no one voted for, has such a thing as jurisdiction. Wow. Upon receiving a complaint that may be governed under section 6, 7, or 8, the chair will forward the complaint to the UNK Faculty Senate Super Committee to determine if the complaint should be assigned to the Academic Freedom and Tenure Committee for adjudication. Yeah, okay, because they can definitely adjudicate things. Once the Super Committee assigns the case to the Academic Freedom and Tenure Committee, the chair will call a meeting of the committees or committee as soon as possible. The committee will first review the complaint for the purpose of determination whether the complaint falls within the jurisdiction of the committee as described in section 6, 7, or 8. They don't have jurisdiction, so here they're attempting to found fraudulent jurisdiction. If the committee finds that no actionable grievance has been stated, or if the committee finds that the complaint for any other reason does not fall within its jurisdiction, it doesn't have any jurisdiction, it will return the complaint to the Super Committee for either reassignment to another committee or to the complainant stating the reasons for the committee's findings. In making determinations as to jurisdiction, the committee shall be guided by the bylaws of the Board of Regents. And here again we go with elevation of the bylaws of Board of Regents above federal and state statutes, and of course the Constitution, the quote supreme law of the land, as according to the Constitution itself. In cases where the committee has initially declined to accept a complaint as actionable, the complainant may, within 7 working days after receipt of written notice of such action, refile his or her complaint or file an amended complaint with the committee and request the committee reconsider its action. That is amazing. So basically they are saying, they are claiming, of course, this is so criminal, they're claiming that if a person has a problem, their only matter of recourse to a committee decision is to ask the committee to reconsider. That's amazing. The committee will reconsider the question of whether it should accept the complaint or amended complaint if upon reconsideration the committee finds that no actionable complaint within its jurisdiction doesn't have any jurisdiction has been stated, or that it does not have jurisdiction. Yes, of course, it has no jurisdiction over anything. Such findings shall be final, and there shall be no further proceedings before the committee with regard to the original and amended complaint. Now, this last part's really disturbing, and that is section 3.6, committee access to personnel records. We should probably change that to personal, because that's likely what they mean. It states, in connection with the formal investigation of a complaint, it should be considered a legitimate educational and, notice that, it shall be considered a legitimate educational and institutional interest for the committee to examine any university personnel records considered by any person or body in taking the action or making the decision which is the subject of a complaint. That is so criminal in so many different ways. It is spectacular. Just on the surface, that's misappropriation of personal identifiable information, that's abuse of authority, that's intentionally administering things for stuff that it's not intended for that purpose. There's so many things messed up with that right there. Anyway, it says the committee shall be subject to and shall observe all laws. Yeah, I doubt that. Policies and rules and regulations pertaining to preservation of the confidentiality of such records. Oh, wow. Like they have authority to subpoena. That's a subpoena, by the way, what they're talking about, but they don't have the authority to subpoena anything. It's spectacular. And in continuation, under subsection B, it states, the committee at its discretion shall call either of two types of pre-hearing conferences. Okay, so now they can hold pre-hearings. In one type of conference, the committee confers with all parties concerned in an effort to delimit the specific charges to be heard. And of course, now they hear charges. Yes. That's something that a faculty senate committee is capable of doing. In the other type of conference, both parties are offered a final opportunity to informally settle or withdraw the complaint. Under C, it states the faculty member, at least one working day before the hearing is scheduled to begin, may ask the committee that the hearing be private, and upon the showing of good cause, the committee shall grant such request. In the absence of such a request, however, the hearing shall be public. If the hearing is closed, the record of the hearing shall be public and available for inspection after the disposition of the case. The president or the faculty member and their respective lawyers or advisors, and now this faculty senate committee is able to hold hearings where they hear about charges given by lawyers or advisors. In continuation, it states, shall have the right to be present at the hearings at all times, as may any observer who has been sent by a previously invited academic or professional association. Yeah. Under E, the chair of the committee may preside over the hearing. Yeah. Preside over the hearing. The hearing shall proceed as follows. 1. The evidence submitted by the president in support of the complaint, the faculty member's evidence in support of his or her answer, the rebuttal evidence in support of the complaint, the rebuttal evidence in support of the answer, closing arguments. However, in rare cases, if the committee decides that a clear and more orderly way of exploring the issues can be achieved by varying the normal order of proceeding, it may so order. No, it may not so order because it's not a court. Testimony of witnesses. So yes, they can hear testimony too, apparently. And other evidence shall be received by the committee in accordance with section 4.14.2c of the bylaws. The university shall cooperate with the faculty member and his or her lawyers and advisors in obtaining pertinent information, in requesting the presence of witnesses, and in producing other evidence relevant to the issue of the hearing. Now, mind you, anybody, any lawyer or attorney, any single individual that recognizes the authority of this fraudulent court is engaging in the same thing that these people in the faculty senate are doing, which is acting under the color of law and a boatload of other criminal offenses. Quite spectacular. As I have repeated that, there's very few words that can describe this situation and the extent of the stupidity that is involved here. The testimony of witnesses not available for the hearing may be presented by depositions taken in accordance with the statutory provisions applicable in the civil courts in the state of Nebraska. Wow. And there they clearly state that they believe themselves equivalent to civil courts. So either that states the civil courts are not to be taken seriously, or that either way it makes the civil courts look like morons, because this type of thing is being allowed to happen, and the people that have perpetrated this type of thing are still in their positions and still collecting paychecks. In continuation, other taking of depositions shall be decided upon by the committee in pre-hearing conferences. In all pre-hearing matters, the committee may, on its own motion, or at the request of any party, enter such orders in its discretion as justice requires to protect any party from annoyance, expense, embarrassment, or oppression. The committee shall have the right to summon and question witnesses. Yeah. All parties, their representatives, and their counsel shall have the right to question all witnesses and to present other evidence relevant to the issues. The committee, in its discretion, may exclude witnesses from the hearing room except to testify. If the charge is professional incompetence, individual testimony of cognate colleagues within and without the university may be admitted as evidence. If the faculty member so requests, formal departmental reports by colleagues in cognate departments within university may also be admitted in evidence. All department reports shall include both majority and minority opinions. In continuation, B, an invitation to the I believe this is a different subsection, but an invitation to the faculty member to attend a personal conference at a time, place, and date stated, and that he or she may, but is not required to, appear with such council or association advisors as the faculty member deems necessary. Yeah, this committee court cannot require anything. They are so criminal. A copy of these procedures, together with an admonition that any statement or arguments made in informal conferences may later be used as admissions at a formal hearing. So, an admonition is generally considered, well, if you look up the definition, which you probably can't trust, considering these people write the definitions, but admonition, legally speaking, mostly relates to an actual punishment. And then the ability to use statements or arguments later in proceedings is what is commonly referred to as Miranda rights. So here, they have the audacity to include Miranda rights into their committee proceedings. Yep. D, a statement that a personal conference can be successful only if a bona fide effort is made to find a solution to a common problem. To this end, the chancellor will present the university views and welcome the views of the faculty member. Either party to the informal conference may request that a record, digital recording, and or written transcription of the conference be made. Procedure after resolution by mutual consent. If the dismissal matter referenced in section 4.2 is concluded by mutual consent, the chancellor shall set forth the settlement within 15 calendar days in a letter sent to the faculty member unless the parties mutually agree that this is not necessary. In this section and a few others, they've actually highlighted some rather interesting components that are under G, respondent. Respondent shall mean the person, persons, or body which took the action or made the decision that is the subject of a grievance. It's very odd wording there. They probably don't even know what a person is. And that you can have legal persons, because otherwise they would not have referenced body, mind you, because there's two types of persons. There's two overall types of persons. There's a human person and there's a juridic person. And most legal entities only recognize the second, or former. Under H, it states working day, also business day. A working day or business day shall be any Monday through Friday on which university classes are in session or examinations are being held. So here they even have the audacity to stipulate what a working day is. Yeah. Working day shall also be interpreted to include weekdays during which academic operations are ongoing using online resources during periods of emergency declared by the chancellor. So now the chancellor has the ability to declare emergencies. Faculty Senate Coordinating Committee, aka Super Committee, a committee comprised of the president of the Faculty Senate and the chairs of the Professional Conduct Committee. None of these people are elected individuals. Nobody gives a crap about their opinions. They are self-appointing themselves into ridiculously... It's just... yeah. No words. There's no words to describe this stupidity that's being demonstrated here. And arrogance. Just outright blatant arrogance. Grievance Committee, Academic Freedom and Tenure Committee, and UNKEA for the purpose of coordinating activity among faculty senate committees. And then they have a specified time limit for filing grievance. And here in this next part, we have so many amazing declarations by this extremely arrogant academic institution. And on the other hand, these people are not intelligent enough to come up with such a scheme on their own. So you have to imagine that this type of thing is going on at all other institutions. They all work together. They all collude together. There's no way that this little committee court is an isolated incident. It's highly unlikely that this is an isolated incident. In continuation, it states that under subsection J of section 5.8, the committee may proceed independently to secure the presentation of evidence at the hearing by directing the parties to produce evidence on the specific issues that it deems significant. Under K, it states the burden of proving the charges. They're using legal jargon, but they don't have any real power, so it's just, yeah. The burden of proving the charges shall rest on the party bringing them, and proof of each charge shall be preponderance of evidence relevant to each charge. Under L, a verbatim record of the proceedings shall be kept by a court reporter or by tape recording, and a full transcript shall be made available to the committee and to the parties. The cost of such a record and transcription shall be borne by the NU system. The committee may, in its discretion, adjourn the hearing from time to time to permit the parties to obtain further evidence. The committee may request written briefs from the parties and shall accept them if they are offered. The committee shall have the right to select and hire a lawyer to assist in conduct proceedings. The lawyer selected must be agreed to by the General Counsel of the NU system, the President of the Faculty Senate or designee, and the Chancellor of UNK or designee. Any General Counsel that agrees to this type of crap is, well, you know, they're just equally culpable, I suppose. I don't really know how much higher you can get in the level of criminality than setting up your own kangaroo court. Section 5.9, Committee Decision Basis Deliberations in Executive Session. All committee decisions shall be based solely upon the record made at the hearings, except as specified in Section 5.10. All deliberations shall be conducted in executive session with only members of the committee, and if the committee so decides, its lawyer. Section 5.10, Hearing record required before final decision is made. Party with burden of proof. Here we go with that word again, burden of proof. Ugh. The committee shall await the availability of the verbatim record of the hearing before proceeding to its decision. Unless the committee believes that it can render a just decision in the absence of such a record, in all cases the committee shall render its decisions with full consideration of the fact that the burden of proof rests upon the party bringing the charges. Section 5.11, Justification of committee decision. In all cases, the committee shall provide specific findings of fact to support its conclusions on each of the charges submitted as grounds for dismissal. Now notice that word there, in all cases. I highly doubt that this committee fraudulently appointing itself as justices of whatever stupid laws they're making up here, I highly doubt that they are going to do what they're claiming here to what we believe to be a real court, because they're not a real court, so they would prefer to keep this stuff as secret as possible. In continuation, a copy of the opinion setting forth the committee's disposition of each issue in the case with its accompanying reasons to justify such disposition shall be made available to each of the parties and to any invited observer of professional association at the time when the committee announces its decision in the case. And there it does appear they're using the word disposition correctly, surprisingly. Now also, it would be a good note that this document is from April of 2020. And as we all know, April of 2020 was a rather chaotic time. So it's no surprise that they appear to have gotten away with this type of thing, because they would have been overshadowed by certain events that were at the forefront of people's minds at the time and their perception. Now, again, we get another section talking about access to personnel and student records, but above that, in a paragraph, it states all persons meeting with the committee shall be or will be requested to respond to questions by the committee and give testimony relevant to the grievance. Any person meeting with the committee may, in addition to his or her oral testimony, submit a written statement. The committee will interview all witnesses suggested by the parties, except where it appears that the testimony of witness would be A, unduly repetitious of evidence already presented to the committee, or B, irrelevant to the grievance. The committee may also call other witnesses which it believes may have relevant testimony. Now we get another mention with that access to records, which they have no subpoena power. So this is just mishandling and misappropriation of this in itself is breaking the law of confidentiality of records and intellectual property and all that, which is a clause in the Constitution that states no person shall be deprived of life, liberty, or property without due process of law. This is not due process of law, and therefore anybody who has their life, liberty, or property deprived of by this fraudulent court committee is, well, they're being deprived of life, liberty, or property without due process of law. So, in Section 10, it states that in connection with the formal investigation of a grievance, a formal investigation, it shall be considered a legitimate educational and institutional interest for the committee to examine any university personnel and student records considered by any person or body in taking the action or making the decision which is the subject of a grievance. Now, again, as an added note, the repetition of person or body tells you that the writer of this document does not know what a juridic person is. A body, as they're referring to, as they believe their faculty senate to be, would be a juridic person. So it wouldn't be mentioned a body. The committee shall be subject to and shall observe all laws, policies, rules, and regulations pertaining to preservation of the confidentiality of such records. Well, in the simple request on a fraudulent subpoena, they are breaking the confidentiality of such records. And then we have this other section about impeding investigation and that it'll be forward for remedial action. And then they have a section talking about standards for consideration of a grievance. Now, under the section titled Faculty Grievance Committee Rules and Procedures, we have them self-directing powers, or otherwise administering powers to themselves. Here it states that a faculty grievance committee shall have the powers specified in section 4.13.2 in addition to any other powers granted by the faculty governing agency pursuant to these bylaws. From the Board of Regents bylaws, 4.13.2, Powers of Faculty Grievance Committee. Any faculty grievance committee established under section 4.13.1 shall be empowered A, to consider a complaint filed by any faculty member alleging any grievance. B, to seek to settle the grievance by informal methods of adjustment and settlement. Notice those words, adjustment and settlement. These people have no position, authority, or understanding to be able to execute something like an adjustment and settlement. Those are very specific words that relate to monetary damages and other such concepts. They're monetary. Adjustment and settlement are monetary things generally, and I suppose they could relate to like property and other things like that, land and maybe even services. But either way, adjustment and settlement are very specific legal jargon terms that actually mean something, but the way that they're being used here If they do mean what they're supposed to mean, that is just yet another in the long list of criminal activities being done by this institution, operating under the color of law and far, far outside their scope of duties. Anyway, in continuation, either itself or by using the services of any officer or body directed to settle grievances and disputes by mediation, conciliation, or other informal methods. C. To draft rules of procedure for the orderly and fair handling of grievances by the committee, which rules shall become effective after notice and hearing when approved or modified by the board, and upon approval shall be effective as part of the rules of the board. And D. To proceed, if informal methods fail to resolve the matter satisfactorily, with further proceedings to be conducted in accordance with the rules of procedure approved by the board under this section in accordance with the following principles. Now, mind you, the Board of Regents does not have the authority to do what they're apparently doing here. None of these people have anything even closely resembling the authority to do any of the things that they are doing here. It's just, they just declare authority and jurisdiction over stuff, and if they're not challenged, then they just assume that means that they're safe and sound and they can do whatever the hell they want. Anyway, under 1, if the grievance alleges that inadequate consideration was given to relevant matters by the person or body, and there again we go, that repetition of person or body, and it does seem like the person that wrote this thing from the Board of Regents bylaws also wrote the other things and does not know what a juridic person is. Anyway, that took the action or made the decision that led to the grievance committee shall investigate the facts, and if convinced that inadequate consideration of the relevant matters occurred, state the facts found and the respects in which the consideration was inadequate. The committee may order the matter reconsidered by the appropriate person, group, or groups, or recommend that other rectifying action be taken. The grievance committee shall not substitute its judgment on the merits for that of the person, group, or groups that previously considered the decision. 2. If the grievance alleges that a discontinuance of a department or program is not bona fide, or that no extraordinary circumstances because of financial exigency exist. There we get another jargony term of a legal term that, if it means what it's supposed to mean, it's this is like clear-cut fraud, as well as acting under the color of law and a bunch of other stuff too. The committee shall investigate and state its factual findings, conclusions, and recommendations in writing, which shall be filed with the Chancellor of the major administrative unit involved, the complainant, and the faculty governing agency. So here we have two things going on here. First of all, one of the main powers that a legitimate court has is financial. It's financial repercussions for criminal activity or civil activity or things like that. So they are abusing their ability to administer financial and monetary resources. That's the first one. The second thing is that they are abusing their ability to administer confidential information, such as personal identifiable information, PII, like addresses, a medical history, and things like that. They're abusing their abilities to administer that stuff in the interest of setting up their own fraudulent court system, and they're using that position that they obtain to administer those things as a way to make themselves into justices and to apply repercussions for things that they see as breaking their laws. So that is that's the practical mechanism that they're setting up, or have set up, to build a fraudulent court, essentially. Because the court system only has 3 things that they can do to a person. They can do monetary things, they can do physical things. Well, actually, I suppose that would just be 2 things then. They can do things that are monetary and physical things. That's it. That's all you got. Physical and monetary. And so that's basically what they're doing here, is establishing physical and monetary ramifications for people that break their self-written laws because of their self-appointed position as faculty justices. And then it also states that all evidence and testimony from witnesses will be fully available to the grievant, and the grievant will have the opportunity to address questions and to directly cross-examine any witnesses. No member of the committee shall hold any administrative position above the level of department chair, regardless of faculty status. And here we get notification of academic/professional organizations. It states that upon written request of the faculty member, a separate copy of the complaint shall be sent by the president to the appropriate academic or professional organizations, accompanied by a formal invitation for the organization to send an observer to the proceedings, if it should so choose. Then we have time period for response, and then it says faculty response to academic/professional organizations. And here in section 5.6 we get committee authority over objected evidence. If evidence is tendered during the hearing which is objected to on the ground that it is not within the issues raised either by the complaint or by the answer, the committee will either 1. Not allow the evidence, or 2. May allow either the complaint or the answer to be amended, and shall do so freely, especially when the presentation of substantive issues will thereby be facilitated. I believe that should be written substantial issues, but perhaps they're using a legal jargony term that I'm not really familiar with. Substantive issues. Whenever an amendment has been allowed, and here they can do amendments also, of course. Naturally, why not? They can do everything else, right? And the other party so requests, the committee shall grant the other party a reasonable time within which to prepare a response to the new issue or issues raised. And here we get another reference to a legal term called default judgment for the university if the faculty member does not respond. Now, a default judgment, generally speaking, refers to bankruptcy trials or a case charge that relates to a loan or something like that, and then a judgment is put into the court which leads to a lien, such as a lien on a house or a vehicle or something of value. And then the lien is removed after that person pays off the so-called debt. Judgments usually have to do with credit report. This committee is using this wording in a way that cannot mean that, because there is no feasible way that they can inflict judgments on people. So what it states is that if the faculty member fails to answer the president's complaint or state that he or she desires no hearing to be held, the committee shall find in favor of the university by default. That might be a default decision, but that's not a default judgment. Very interesting. And then we have investigation procedures, as if that's also something that they're able to do. So here they're just wrapping everything together, legislative, judicial, and executive all together. They can just do all of it. They are so powerful, they can do whatever they want. And here, of course, they have this other clause stating no subsequent grievance may be taken to the committee from a reconsideration oversight panel. I believe that is pretending to be the clause stating that no jury decision can be retried from the Constitution. The supreme law of the land, Constitution, the U.S. Constitution, not their fake Constitution, that they clearly have one of those too. And then they have sections that talk about disqualification of members, consolidation of grievances, vote required, decorum. And here we go with even more declarations of authority. It states under subsection F, I don't even remember what section this is under. Proceedings closed. All proceedings before the committee under these rules of procedure are considered to be investigative in nature and shall not be open to the public. Yeah. Again, they would prefer to do this stuff in secret because what they're doing here is extremely criminal. Finality, well, I mean, I suppose you can't really be extremely criminal. You're a criminal or you're not, but this is criminal. Finality of proceedings. When a grievance has been settled by informed procedures or when the committee has rendered a report on a grievance pursuant to its formal procedures. Also, I should add a note that unlawful is what they're doing. What the things they're doing are unlawful, but they're not just unlawful. They are directly breaking the law, the supreme law of the land. And the word the term crime has been screwed with a lot. And the only reason why I use that word is because using the other words of what they're doing just don't carry as much weight as calling something a crime. But the words used still do not change the nature of the conduct. So even if I use the incorrect term or I use the wrong word, it does not change what they're doing. It just means that maybe I got something wrong. Anyway, the proceedings of the committee with respect to such a grievance shall be at an end, and the same grievance shall not thereafter be again considered or acted upon by the committee. And there you get a copy, acting under the color of law, of the part in the Constitution that states that no decision tried by a jury shall be retried afterwards. That's what they're copying there. Withdrawal of a grievance. Proceedings of the committee with respect to any grievance shall be terminated upon the filing of written withdrawal of the grievance by the grievant. Participation by attorneys in committee proceedings not allowed. The grievant, a respondent, and other persons meeting with the committee and the committee itself shall not be represented by attorneys who are present at committee proceedings. The grievant, a respondent, and any person meeting with the committee may at their personal cost and expense be assisted by the private attorney of their choice in preparation of written materials and documents to be submitted to the committee and in preparation for meeting the committee. Here, this part's interesting. The person writing this knows what a constitutional court is. In a constitutional court that is following the supreme law of the land, which we haven't had one, and I don't believe we have one anywhere, posts the jury as the decision makers. The jury is the judge, basically, in a constitutional court. And in a constitutional court, you are allowed counsel. You are not allowed advocacy, and you're not allowed representation. You're only allowed competent counsel. That's it, in a constitutional court. What they're setting up here tells me that they not only know what a constitutional court is, but they're setting up this fraudulent committee court of the Senate faculty as a joke to mock the fact that we have no constitutional courts. And what we have instead are banking courts pretending to be constitutional courts, with the judges that take oaths to support the Constitution, even though they don't do that, and they pretend they act under the color of law. And this tells me that they know what a constitutional court is, and they're doing this as a joke, basically. A joke on all of us. Under I, it states, the committee may request that the General Counsel of the University of Nebraska to provide legal counsel to the committee. The committee may also request the advice and assistance of appropriate professional consultants, e.g. a psychiatrist, a technical expert, an ethicist, an accountant, experts within a particular discipline. The committee shall have the right to select and hire a lawyer not otherwise affiliated with the university to assist in conducting hearings. The lawyer selected must be agreed to by the General Counsel of the University, the President of the Faculty Senate or designee, and the Chancellor of UNK or designee. The committee also may ask other persons who appear to have knowledge of the matter under investigation to meet with the committee. The university shall not, without good cause, refuse to provide financial and other resources necessary for the committee to obtain such expertise, the cost within reason of such expertise not to be considered good cause. Notice that end part right there. This Senate Faculty Committee is directing the university about what it can do. And here we get yet another level of criminality. In section 5.13, it states that no public statements about cases in progress. So here what they are doing is using the color of law. They are attempting to coerce activity by stating that except for such simple announcements as may be absolutely required, such as the time and place of meetings and similar matters, no public statements by involved parties about the case shall be made until after the final decision has been rendered. They have no business writing something like that. That is coercive, and it's criminal. It's unlawful, it's wicked, and evil. And here we get in Section 6, termination of services of untenured faculty members alleging violation of academic freedom. And here in Section 5.7.5, we get another reference to possible ramifications. It states that upon concluding the investigation, the committee shall compose a written final committee statement on the complaint consisting of the committee's findings and recommendations. Copies of this will be sent to each respondent, the complainant, the chancellor, the vice chancellor for academic affairs, and the president of the faculty senate. The committee shall also send to each respondent a copy of the written complaint originally filed with the committee by the complainant. All copies and documents required in these procedures may be sent via UNK email systems, unless otherwise indicated in these procedures. How clandestine. And under Section 8, it states complaints of faculty members alleging non-uniform application of university-level evaluation, promotion, and tenure guidelines. UNK Faculty Senate Bylaws, Article 7C, stipulates that the committee has oversight responsibilities to ensure that the university-wide rank and tenure standards and procedures are applied uniformly by the undergraduate colleges. Spectacular. And here we get some more interesting parts here, but I'm not going to cover them. It's a sort of repetition of earlier passages. Under Professional Conduct Committee Rules and Procedures, it states from the Board of Regents Bylaws 4.15.2 Powers of Professional Conduct Committee, a Professional Conduct Committee shall be empowered, 53A, to receive complaints from any person charging a member of a professional staff, as defined in Section 3.1.1 of these bylaws, with professional misconduct. B, to investigate the facts relevant to the charge and to make factual determinations. Said investigation shall include advising the affected party of the charge, hearing his or her response, and considering any evidence produced by such party. C, conclude whether there are reasonable grounds to believe that the person against whom the charge is directed committed acts that amount to professional misconduct. D, to advise the person filing the charge and any other appropriate persons or groups of the committee's conclusion and factual findings, and to recommend to the appropriate university officer or group whether action should be taken with respect to the charge and nature of such action. Yeah, well, taking any action based off of that fraudulent garbage is act under the color of law. So go figure. To recommend sanctions less severe than appointment termination where the committee judges, and here it states they're committee judges. Yeah. Less severe sanctions appropriate. And here it's got their committee makeup rules, which are extremely arbitrary and ridiculous. It states that all elected, they're not elected. Anyway, it states all elected faculty shall be tenured and hold the rank of assistant professor or above. Yeah, elected by whom? Below that, it states the committee shall be composed of one faculty member from each of the undergraduate colleges, one faculty senator elected by the faculty senate. I don't believe elected is the term there, but one at-large member of the faculty, not a member of the faculty senate, the faculty senate president-elect, and one non-academic professional staff member selected by the administration. The committee members shall be classified with respect to the time for which they shall severally hold office by dividing them into two classes, each consisting as nearly as may be of 1/2 of the whole number of the committee. Blah, 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 blah. And here we get more definitions with the interesting definition of a working day. Here's an interesting part that has been highlighted, and it states that shall not engage in any activity that could be characterized as research or scholarship misconduct, including the fabrication or falsification of data, plagiarism, misrepresentation, or the failure to conduct research in accordance with the requirements of any outside funding source. I have to wonder what that outside funding source might be. perhaps might carry a red star, maybe? And here we get two ridiculous sections. First one, number 5, is, again, jurisdiction. They have no jurisdiction. They are claiming jurisdiction. It's not the same thing as actually having jurisdiction, though. And then 4, presumption of innocence. They have a presumption of innocence clause. Quite spectacular. It states that any professional staff member who is accused of professional misconduct under the procedures provided herein shall be presumed innocent by the committee. Well, that's nice, as if they have the ability to presume innocence. The burden of proving professional misconduct shall be upon the complainant and the accompanying investigation and inquiry, if any. Unless there is good reason to believe that interim administrative action is required to protect the interests of the public and the university. I also like how they slip jurisdiction over the public in there. No administrative or academic sanctions will be placed on any faculty or staff member under investigation until the committee's final report is issued and responded to by the administration. Under 5, jurisdiction. The committee's jurisdiction extends to all matters of professional misconduct alleged against full and part-time faculty and staff. And here they are claiming jurisdiction over all matters of professional misconduct alleged. They have no jurisdiction, and yet they're deeming themselves the arbiters or the juridical enforcers of all matters of professional misconduct. All matters. They are claiming jurisdiction over both federal and state courts. They're claiming jurisdiction over all matters. All matters. No administrative investigation or procedure shall supersede or substitute for the role of the Professional Conduct Committee in its advisory capacity to administer in regard to professional misconduct, except as provided under the interim administrative action below. Here they are flouting every single law that has ever been written anywhere, pretty much, as it regards all matters of professional misconduct. The scope of authority of the committee shall extend to all activities which involved alleged professional misconduct associated with the University of Nebraska-Kearney employment. And then it's got rules of procedure, super committee. Meetings of the committee shall be scheduled within minimum 6 members are able to be present. And blah, blah, blah. Sufficiency of complaint and determination of jurisdiction inquiry. That's about as you would expect. So I won't cover it. That would be beating a dead horse. Then here it stipulates that the right of the respondent to file an answer, and it states that the chairperson shall call a meeting of the committee as soon as practicable within 14 working days after a written complaint is received, though the chairperson, at his or her discretion and in consultation with the president of the faculty senate, may delay response based on practical considerations, including those arising from emergency conditions on campus. I wonder what those emergency conditions on campus might be. At the discretion of the chairperson in consultation with the president of the faculty senate, a virtual meeting of the committee using online technologies is permitted. And here it states that if the complainant disagrees with the committee's finding, S/he shall have 7 working days to, I'm not even going to play their little game with that, to resubmit or amend the complaint for reconsideration by the committee, though the committee may extend that deadline for special circumstances. Upon receipt of the resubmitted or amended complaint, the committee shall meet to reconsider its original decision. If the committee affirms its original decision that the complaint is insufficient, such decision shall be final. Yeah, sure, they can make final decisions. If the complaint in the opinion of the committee lies outside the jurisdiction of the committee, like all complaints will, the committee will refer the complaint back to the super committee for potential reassignment to another committee. Okay, so if all complaints fall outside of the jurisdiction of the committee because this committee has no jurisdiction, then their response will be just to further it to other people that have no jurisdiction or authority to adjudicate anything. And here we get the whole inquiry section, talking about how their inquiries are going to work and their full and serious and formal investigations and whatnot. And here we get there. 7. Investigation and hearing. Conduct of hearings. The committee shall conduct one or more hearings for the purpose of ascertaining the facts relevant to the allegations contained in the inquiry report. An audio recording of the hearings shall be made and record securely retained by the committee. At the initial hearing, only the complainant, the respondent, and counsel for an advisor for any party shall be present. The committee may hold further hearings at which the complainant, respondent, and relevant witnesses may be present. Witnesses shall be present and interviewed one at a time. The committee chairperson shall preside over the meeting, but all members of the committee may participate in the questioning of the complainant, respondent, and witnesses. Now, I imagine any licensed attorney or other person that goes to these things, if they even do show up, it's a slap in the face, basically. They are being called before a committee of the Faculty Senate of the University of Nebraska-Kearney. And then it states that during hearings, the complainants and respondents may be assisted by counsel or by advisor of their choice. The respondent and his or her counsel may be present throughout all testimony by all witnesses. The respondent and or the respondent's counsel shall have the right to peruse all evidence and to cross-examine all witnesses. This is amazing. The committee shall have the right to select and hire a lawyer not otherwise affiliated with the university to assist in conducting hearings. The lawyer selected must be agreed to by the general counsel of the university, the president of the faculty senate. I read that before, so it's just a repeated section that was previously included. Here's the committee findings and final report. Rights to hearing information. Here we get more declarations of authority. It states that the committee, through its chair, has the authority to inform the respondent of his or her rights to file a counter-complaint or grievance against the complainant. Yeah, they don't have authority to do anything. Just more acting under the color of law there. And here we've got role of the president of the faculty senate, delivery of the final report and disposition of recommendations, transmission of notices, interim administrative action. And here we get guidelines for submitting complaints to the Professional Conduct Committee, amendment of the Professional Conduct Committee Rules of Procedure. And here at the bottom, we have what you'll find as a legal class reference on many documents, and that is adopted by the University of Nebraska-Kearney Faculty Senate, December 5th, 1991, revised January 12th, 1995, revised March 15th, 2005. That is like a revised code. So this university, apart from self-appointing its own senate, self-appointing its own committee courts, and self-appointing its own executive branch to carry out its fraudulent crimes and criminal procedure and regulations and laws, also has its own revised code. Imagine that. Next, we have process for reconsideration ordered by the committee, and the committee report. Here's an interesting clause that's not highlighted but probably should be, and that's where it states that correcting any deficiencies or abnormalities found in bylaws, rules, regulations, or procedures relevant to the grievance. So the interesting part about that is that it would constitute the ability to rewrite their own fraudulent laws and rules and regulations if it does not conform to what they desire. That is specifically a thing that was identified in earlier parts of the U.S. Constitution as a problem, and naturally they would have that included as something that they can do because they are in fact corrupt people and they're criminals. Next, we have conduct of formal investigative meetings, initiation of formal procedures and definition of issues to be investigated, service of the grievance, and the committee's statement of grievance. And all of that stuff, while it is interesting and unlawful, it's perhaps not as egregious as all of the other ones considering the level of hubris being demonstrated here. Initiation of proceedings. Determination of jurisdiction. Upon receiving a complaint, the chair or president will forward the complaint to the UNK Faculty Senate Supercommittee to determine if the complaint shall be assigned to the grievance committee for adjudication. Once the supercommittee in turn assigns the case to the grievance committee, then the chair will call a meeting of the committee as soon as possible. The committee will first review the complaint for the purpose of determining whether facts and circumstances therein alleged constitute a grievance within the jurisdiction of the committee. Yeah. That's just a similar thing in the other parts where they claim jurisdiction over something that they don't have jurisdiction in any concept of the word. And here we get complaints of faculty members alleging violation of academic freedom that do not involve termination. Section 7.1, complaints, disclosure, or waiving of attorney advocate / advocate. That's something. It states the committee's investigation must abide by the stipulations in section 4.14.2c of the bylaws, because it certainly doesn't have to abide by any real laws, because they're just going to completely ignore those here. This language assumes that the complainant will be represented by an attorney or other advocate for complaints in this category following informal resolution attempts. Section 4.1. The committee chair will request the complainant to provide contact information for his or her attorney / advocate or to waive such representation before the committee proceeds with the investigation. And here we get under basic policies, rights of academic freedom statements on tenured and term appointments, and section 3.2, faculty suspension not permitted during a dismissal investigation. Thank you. And if you have enjoyed this content, please like this video, share it, subscribe to my channels, and check out my other work, such as my written content. And there will be free books available. And if you so choose, you may support my work at PayPal or Cash App, or buy me a coffee, or any other form that you so desire. Thank you, and stay tuned, there will be more.